Yes, Mr. Conn.
Good morning, my lords. In this appeal, I appear for the appellant with Mr. Ojo, who appeared in the High Court, and Mr. Dillon represents the respondent, as he did in the High Court. Can I first of all deal with the papers that I hope the court will have? You should have a core bundle with a relatively late edition as the final document, the respondent's notice. That hadn't been included earlier, which apologies. You have a supplementary bundle which currently runs to 43 pages, and on your bench you should have a clip of further documents which runs to 42 pages, which the parties are agreed should be added to the supplementary bundle. And that disposes of the need for the application which the respondent had made. I make no concessions as to the necessity or relevance of the documents, but it seemed a compromise which would save the court time hearing a later application.
Can I just check that I've got the right documents? I have a clip of additional documents. They are numbered in manuscript, top right, from 62 through to 84. Is that correct, or am I missing something?
That is right, yes.
This is no, I'm afraid I'm confused, because the supplementary bundle I have currently ends at page 42.
That's right. I'm sorry. So what I thought you had was a bundle of documents which was numbered following on from 42, so beginning at 43. And the first document is a letter of 28th of July 2020.
No, don't have that. Not, no.
I think there must be some confusion between the parties. I'm sorry, Lord. I understand the confusion now. There are actually two sets of additional documents, one which runs from 43 to 61, which I'm holding in my hand, and the other one then that runs on from there. So we're agreed as to the documents, but I was unclear as to what Mr. Dillon had provided the court with.
Yeah,
so let me hand up the
Please do.
other part of the
Thank you. This gives us a revised index, which is helpful, but this only goes up to page 61 at the moment. I'm not complaining, but just observing.
Yes, that's right, my lord. So I won't bore you with the process of negotiation of the additional documents, but yeah, there isn't a full index. We can provide one after today.
Thank you.
It's been fairly last minute.
Right, now, Mr. Copple, does that mean that we are going to have to look at anything in the unagreed bundle, or can we put that to one side?
You can put that to one side. The parties are agreed that the court has everything it needs without the unagreed bundle.
Thank you very much.
So you should also have a short authorities bundle.
Yes, thank you.
And skeleton arguments from both parties. My learned friend's skeleton argument deals primarily, I believe, in the majority of it is concerned with a cross appeal for which the respondent didn't get permission in the event.
Yes.
My submissions on the appeal will cover the following four matters. Firstly, the factual and legal background, including the shareholders' agreement, the pleadings and the course of the trial. Secondly, the judgments and orders made by the High Court with which you are concerned. Thirdly, the appeal against the judge's ruling on interest. And fourthly, the appeal against the judge's ruling on costs. I'll take a little time over 1 and 2 with the intention that I'll be able to proceed fairly quickly when I get to the actual grounds of appeal in 3 and 4. So, the factual and legal background then. The respondent, who I shall call the claimant, was a partner in a GP practice, as you will have seen, and owner of 1,600 shares in the appellant, who I will call the defendant, which was the property-owning arm of the practice. He was lawfully expelled from the practice in April 2009, and his expulsion triggered the provisions of the shareholders' agreement relating to the defendant, which required the claimant to sell his shares to the other partners in the practice, or to such of the other partners who wish to buy them. Now, can I show you the shareholders' agreement? It is in the core bundle, beginning at page 241. And at 247, clause 10, you have transfer of shares deemed transfer, and the following events shall be deemed to constitute service of a transfer notice in respect of all the shares held by the shareholder suffering or instigating the event in question. And then 10.1.1, a shareholder ceasing to be a partner in the general medical practice carried on by the shareholders.
Now, a small point arises out of the drafting of this provision, which is that transfer notice is given with a capital T and a capital N, suggesting at first blush that it's a defined term. But in fact, so far as I can see, it's not a defined term. Is that right?
That is right, my lord. There are a number of similar such points one can make about the drafting of this agreement. But paragraph 11, or clause 11, is at least contributes towards understanding what a transfer notice is or is supposed to be, and tells us what the contents of a transfer notice must be. It must offer all the shares registered in the name of the shareholder for transfer and constitute the company, the agent of the vendor, the claimant in this case, for the sale of the shares. And then where any transfer notice is deemed to have been given in accordance with this agreement, it shall be treated as having contained each of the matters in clause 11.1. So there was a deemed transfer notice when the claimant was expelled from partnership. And further under clause 11 concerned with preemption, at 11.4, there is a procedure to be applied on receipt or deemed receipt by the company of a transfer notice. And 11.4.1, the company shall, within 28 days of receipt of a transfer notice, determine the transfer price and give notice in writing to the potential purchasers of what the transfer price is. Transfer price is capitalised and is defined on page 243 of the bundle. And it means such price shall be agreed between the vendor and the other of the shareholders, or, so either there's agreement, or in the event that no agreement can be reached, such price as shall be determined by the auditors of the company from time to time, who shall act as experts, not as arbitrators. And then there are parameters for the valuation given fair market value, taking into account restrictions on sale, size of holding, and subject to a 10% discount. Auditors, again, capitalised and defined in 4.3, at least defined as at the present time. The auditors of the company were a firm called Kingston Smith, or such other firm of chartered accountants as the shareholder shall determine from time to time. And Kingston Smith were in due course replaced by a firm called Hubbard Lewis, as we shall see. Hubbard Lloyd, as we shall see. Going back to 11.4.4 on page 248. So there is a process for offers to be made by the other shareholders, allocations to be made on the basis of those offers, and then 11.4.4, upon such allocations being made, the vendor shall be bound on payment of the transfer price to transfer the sales shares comprised in the allocation notice to the member applicants named therein at the time and place therein specified. If he makes default in so doing, chairman, for the time being, of the company, one of the other directors, shall forthwith be deemed to be the duly appointed attorney of the vendor with full power to execute, complete and deliver the transfer of the shares. And then going down to the final sentence of the paragraph, the board shall, upon the transfer of the shares, pay the purchase money into a separate bank account in the company's name and hold such money on trust but without interest for the vendor until he shall deliver up his certificate or certificates, when he shall thereupon be paid the purchase money. Now, important points about 11.4.4 are that the company is empowered to transfer shares for a recalcitrant leaver. So if the vendor does not cooperate with the process, then the company is entitled, the clause provides for the appointment of the chairman of the company or some other director as the duly appointed attorney of the vendor with power to transfer shares. So one doesn't end up with a stalemate simply through non-cooperation. Shares are transferred. Purchase money is held for the leaver, and then once he provides his share certificates, the purchase money has to be paid over to him. And what happened in this case was the company, as I will show you, tried to reach agreement as to the sale price of the shares, failed to reach agreement, had the shares valued. The claimant wasn't cooperating, and the company went ahead and transferred the shares to other shareholders, and then made various attempts to persuade the claimant to accept the price of the shares as valued. So just some references in the supplementary bundle at page 39. I won't go through these documents in detail, but there is a letter of 24th of September 2010 from solicitors on behalf of the company, which offers, going over onto page 40, which offers £20 each for the claimant shares, a total of £32,000, and says that this shall be kept in a dedicated bank account until such time as you can produce your share certificate. So no formal valuation at that point, but an offer of £32,000 to reach agreement, not successful. There was then a valuation which one sees at page 22 of the supplementary bundle by Messrs. Hubbard Lloyd, who had replaced Kingston Smith. On page 22.
You say they'd replaced the previous firm, which of course is right, but they hadn't replaced them as auditors, had they? And that seems to be
yes.
one of the niggling points in the background, which keeps on giving trouble.
Indeed, my lord, and I'll come on to this in a bit more detail.
Sure,
but the point was, although Kingston Smith were named as auditors, the company was exempt from audit.
Yeah.
It was never actually audited, and they were simply the company accountants. And they were replaced by another firm of accountants who did the same thing as Kingston Smith had done, i.e. Hubbard Lloyd. And yes, one has this interesting point of construction as to whether the company accountants replacing Kingston Smith can be considered to be the auditors for the purposes of the process.
But there's no dispute that, as a matter of fact, the replacement was simply as accountants, not as auditors, because there was never any need for auditors.
That's right, and there are terms of engagement which say that.
And I've had a look at the terms of engagement, I think, and also, indeed, the valuation itself makes it very clear that they're not auditors.
Indeed, and that's the passage I was about to show you on
Yep.
page 22, under section 2,
Yes. Yep.
second paragraph down. They are preparing the report as accountants for the company.
Yes.
And they come to a valuation of £15 per share, that's page 25, and the date of this, I should have taken you to page 20 is the 30th of March 2011. So that was the price for which the claimant shares were sold to the individuals who purchased them. £15 a share. And then there were various attempts made to persuade the claimant to accept £15 per share. And again, I'll just give you some references. Page 41 of the supplementary bundle.
Sorry, just before you go on, so after this valuation of £15 per share, you say that was the price for which the shares were sold, and
yes,
on one level I understand that, but can we be a little clearer as to what, in terms of machinery, actually happened? So the shares were acquired by other members of the partnership for that price. But what happened with regard to the certificates?
so the certificates have never been provided, even to this day. As I understand it, the shares were formally transferred in November 2011. And the £15 per share paid to the company at that point. But the claimant has never provided his share certificates.
But has the company therefore executed transfers using the power under the agreement?
That is what we say has happened, yes. As the duly appointed attorney, I think it was the chairman of the company.
Thank you.
And this.
Sorry, just before we leave that, is there also a further point about the price? It was the £15 per share was before the 10% discount, which is required, I think, in the definition. And my understanding is that was then picked up. And in fact, the price paid was £13.50. I got that wrong? Or I see a nods behind you.
I'm sorry. I'm sorry, not you are right. So the £15 less,
Yeah.
less 10%. Thank you. I'm sorry, what Mr. Ojo in fact tells me that the people who purchased the shares did pay £15. The company didn't apply the 10%.
Oh, I see.
Should have done.
Sorry. But they should have done. I mean, anyway.
I'm not sure it matters, but the
Yeah.
the point, the greater point, is that the claimant himself was offered £15
Yes.
Per share without the 10% discount on a number of occasions, and just to give you some references to that, page 41 of the supplementary bundle. There's an 18th of May 2016 email informing the claimant that the company accounts include provision for £24,000 payable to him. Please will he accept it? On page 37 of the supplementary bundle, there's a letter of the 4th of January 2017, and on page 38 in the third paragraph down, the defendant says, "We have said all along that the proceeds of sale of the shares of your client amounting to £24,000 will be paid to him on production of the share certificate and the return of the cheque sent to him in 2011.
I beg your pardon, I've lost where you were.
I'm sorry, 30. So I started on 37, which is the beginning of
Yeah.
the 4th of January 2017 letter, and on 38, 3 paragraphs down.
Ah, yes, I found it. Thank you.
And there's another letter on 35 of the supplementary bundle, 28th of August 2019, where the company says in the second paragraph, 4 or 5 lines down, that the sum of £24,000, which represents the total sum due from the sale of your shares, remains with the company. Keen to have the matter finally resolved and ask to understand his position. And that's the penultimate paragraph of the letter, asking him why he, essentially why he's not accepting the £24,000. That was the 28th of October, the 28th of August 2019. Proceedings were issued by the claimant on the 30th of October 2019, so 2 months after that letter, more or less, and that's page 196, is the original claim form, 30th of October 2019, and in order to see what was claimed, it's easiest to look at the amended particulars of claim that begin at 208. The particulars of claim were amended after significant parts of the claim were struck out by Deputy Master Henderson on the 3rd of June 2020. And the key points to make for our purposes in relation to the amended particulars of claim, beginning on page 210, there is a claim in relation to the shareholders' agreement, beginning with renumbered paragraph 10, and then at renumbered paragraph 12, an allegation that the procedure in clause 11 of the shareholders' agreement had not been followed for various reasons. They're set out: price not agreed, price not determined by any auditors, and complaints about Hubbard Lloyd having done it, complaints about another firm having been involved, and so forth. Then at paragraph renumbered 13 on page 214, there's a claim for repayment of partnership capital, which hadn't been struck out by Deputy Master Henderson, but was subsequently discontinued for the trial. And then one comes to the relief at renumbered paragraph 16 on page 215. And the claimant sought relief against the company. Firstly, a declaration that the claimant is entitled to 1,600 shares. And secondly, renumbered Roman 2, an order that the 1,600 shares be valued pursuant to the shareholders' agreement, and the monies being their ascertained value paid to the claimant together with interest accrued.
And that pleading is in breach of CPR 16.42 because it doesn't specify the basis of the interest claim. But as I understand it, no difficulty arises out of that because it was subsequently clarified that the claim to interest was based upon Section 35A of the Senior Courts Act, and no point was taken about the absence of pleading.
No pleading point was taken. My learned junior did complain at the interest hearing that he didn't know what the basis for the interest claim was, but as matters turned out, the judge held that Section 35A was in play.
Well, you will correct me if I've misunderstood, but I thought that the claimant clarified that Section 35A was being relied upon. Certainly that seems to be the basis upon which the judge proceeded.
Well, Lord, it's a little complicated. Mr. Dillon in due course will tell you if that was his positive case or not, and we'll check the transcript. But
all right, but would I be right in saying that no other basis was kept?
No other basis. Certainly no contractual basis was suggested.
Right.
Or other statutory basis. I'm sorry to appear to be difficult. There was the complication is that there was incomplete argument, shall we say, on the basis for interest at the interest hearing itself, but the judge in any event included reasoning as to the basis for interest in his finalised judgment.
Yep.
And that's the basis on which we proceed.
And I'm sure you will be coming to this, but for the purposes of Section 35A, it may perhaps be relevant to note that the relief sought even post-amendment includes not only a declaration, but also an order that the monies being the ascertained value should be paid together with interest,
Yes.
albeit that pleading is defective for the reason my lord has stated. But it does, from one point of view, lend perhaps some plausibility to the argument that this is a claim for a sum of money.
Well, yes, Lord, and we say, and I will come to it in due course, that the claim for an order that the shares be valued and value paid is a claim for specific performance of the shareholders' agreement, rather than a claim for debt or damages. That's the way that we put his argument. Obviously, I'll come on to that.
But the other thing that's odd about this pleading is the first declaration that's sought. A declaration the claimant is entitled to the 1,600 shares. Now, number one, that wasn't in dispute. Number two, the whole point of this was that it was preemption, and so it was all about him selling his shares.
Yes. Lord, as I understand my learned friend's thinking, the thinking was that the claimant wanted to establish that he was still the owner of the shares, notwithstanding their transfer under the shareholders' agreement, and that he would then be in a stronger position to sell them for a higher price.
He claimed he wasn't still the owner.
He wasn't still the owner. Absolutely. He was entitled to the price for them, and that was never in dispute. But he certainly wasn't still the owner. And the other point to note about the relief claimed at struck out subpara 2 and subpara 4 is that there had been a claim for conversion of the shares, and that was struck out following the ruling of Deputy Master Hanson. I understand the reason why it was struck out was because it was time barred. Because of course the claim is brought in in 2019 in relation to events that happened in 2010-2011. But in any event, no claim for conversion remained. The defence then, which responds to the amended particulars of claim, begins at page 218. And from paragraphs 17 onwards in the defence, starting at 222, there is a lengthy response to the allegations of breach of the shareholders' agreement. And you'll see at the end of the first paragraph of 17, it says the first defendant relies on the following facts to demonstrate that the 1,600 shares were transferred in accordance with the shareholders' agreement. And the facts relied on include 17.7, the offer that I'll show you in a few moments, an offer of 3rd of July 2020, where a cheque for £24,000 was sent to the claimant on the 3rd of July. So the defendant is continuing to offer the purchase price. Paragraph 18 admits that clauses 10 and 11 of the shareholders' agreement applied following the claimant's expulsion. Paragraph 20.2 on 225 is the argument about auditor versus accountant. Admitted transfer price not determined by auditors small a of the first defendant, but they were valued by the company's accountant / auditor who had replaced Messrs. Kingston Smith. So that's the argument. And in paragraph 25. On 229, there is a denial of relief. A denial that the claimant is entitled to any further relief, and I understand what was meant by that is the claimant was being offered, it having been accepted that the claimant was entitled to the price of the shares, he'd been offered £24,000. He'd been sent a cheque fairly recently, and the defendant's position was he was entitled to nothing more than that from the proceedings. There were various offers to settle the proceedings, some of which are referred to in the judgments of the High Court. And again, I'll just give you some quick references in the supplementary bundle at page 26. And that's the 3rd of July 2020 letter, which is an open letter, page 26. And on page 27, the 3rd paragraph up from the bottom, having recounted the history of the matter, we are once again instructed to send you a cheque for £24,000 being the payment for your client's shares transferred. Cheque is enclosed. We request you ask your client to cash the cheque immediately, and this is not dependent on whether or not he accepts the transfer value of the shares. So he can just have the money. He doesn't need to concede anything, but the company wants him to accept the money. And that's further emphasised, page 28, 2nd paragraph down. If the court determines the shares are worth more than £15, he will be entitled to recover the difference. There's a further offer a couple of weeks later, page 29, 15th of July 2020. And it's the offer set out on page 31. It's £15 a share. Defendants won't seek to enforce the 10% discount as provided for in the definition of transfer price. And the claimant should pay 50% of the defendant's costs of the proceedings. So not a Part 36 offer. Reason for that is that the claimant had already spent, it was understood, well over £100,000 on the claim by that stage.
I'm sorry, what was that figure?
The claimant had spent well over £100,000 by that.
The claimant?
The claimant had. Sorry, I think I misspoke. The claimant had.
No, you didn't misspeak. I was just checking that I had understood you correctly.
Oh, I'm sorry. The claimant had expended a substantial amount of costs, and the defendant wasn't prepared to offer to pay his costs of that order in a claim that was worth no more than £24,000 best. And there is a further offer on the following page, which we will see referred to by the judge, page 32, a Calderbank offer without prejudice, save us to costs. And this is an offer of, see page 33, £30,000 in respect of the proceeds of the shares, open for acceptance for 14 days. And if accepted, the first defendant will not seek its costs. So a drop hands. And by the time that the case had came before the court for trial, the parties had agreed to instruct an expert to assist the court in valuing the shares. And there's Kate Hart. And page 114 of the core bundle in the judge's trial judgment, page 114 at the top of the page, he refers to the order appointing Ms. Hart as an expert to conduct the valuation of the shares and prepare a report. And he says,
just as a matter of interest, do we have a copy of that order anywhere? I mean, it's not essential, but if it is somewhere, could you give me the reference?
we will. Yes, so that is on page 2 of the supplementary bundle,
That's helpful.
and page 6 is the expert evidence provision.
Right, thank you.
And going back to 114 of the core bundle, the judge, having referred to that direction, says, in effect, therefore, the parties agreed a variation of the 2006 shareholders' agreement for the purposes of this valuation and sale. It is to be implied that the parties wish the court to determine the value based upon the expert opinion directed, rather than for this expert to provide a certificate of value that is agreed. There are, I'm sure, would have been different ways in which one could have interpreted the appointment of the expert in this case, but the judge regarded it as a variation, in effect, of the shareholders' agreement, and there was no dispute about that. So instead of the claimant insisting that the defendant go off and appoint auditors to do a valuation, it was going to be for the court to determine what the valuation was based on the expert report of Ms. Hart. Now, when the matter reached trial on the 4th of May 2022, by far the largest issue on the pleadings remained whether there had been breach of the shareholders' agreement. But the judge, and we say rightly, took the view that that issue was academic in circumstances where the parties had agreed for the shares to be valued by the court with the assistance of Ms. Hart. What mattered was whether Ms. Hart's valuation was a legitimate one or not. The claimant said it wasn't. And it is clear from the trial transcript that the judge was reluctant to hear what would no doubt have been lengthy evidence and argument on the issue of whether the procedure in the shareholders' agreement had been complied with. And you will see from page 110 of the core bundle, paragraph 3 of the judgment, that the morning of the hearing was spent clarifying the claimant's case, and as a result determining whether cross-examination as sought was appropriate. And Mr. Dillon very helpfully identified 12 factual matters relied upon, and Mr. Ojo accepted these facts without the need for cross-examination, and there was no cross-examination. There was an application by my learned friend to amend, see paragraph 4, which was rejected, and the judge went on to consider the challenge to Ms. Hart's valuation. And what one sees from paragraph 1 on page 110 the issues which the judge regarded as being raised by the claim. The first which he says was not in dispute, that's that first plea in the relief section that Dr. Agbaje is to be treated as being entitled to and able to sell his shares. And then that leaves the issue of the value of the shares for which he seeks an order that they be purchased.
So the second sentence isn't strictly accurate, is it? Because the shares had in fact already been transferred some years before.
Yes. So what was accurate was that the claimant had been entitled to sell. He didn't cooperate and they had been transferred. Therefore, he was entitled to the price.
Yep.
Shares. But yes, there's certainly some misunderstanding on the judge's part about that aspect of the relief. So the judge goes on to determine the valuation of the shares, and he determines the valuation in favour of the defendant, upholding Ms. Hart's report, and the value is £13.24 per share, giving a total of £21,188. And that's in the judge's conclusion on page 121. So, substantially less than the claimant had been offered in 2010. That's the 32,000, and still significantly less than the 24,000 which he'd been offered at various points since then. But what is critical for our purposes today is that there are no findings in the judgment on the issue of whether there had been breach of the shareholders' agreement or not. That claim was simply not pursued by the claimant with the assistance of the judge, helping the claimant to narrow down his case to what was really relevant and significant. That claim was not pursued. And there are no findings on it. But by the time one gets to the hand-down hearing, when the issue of interest was decided, the judge has, with all due respect to him, lost sight of the basis on which he narrowed down and then decided the issues at trial. And what one will see from that hearing and subsequent judgments is that the judge seems to have thought that he had decided that the defendant had breached the terms of the shareholders' agreement. So, just to give an example of that, on page 125 of the core bundle, we're into the transcript for the hand-down hearing. At letter H, the judge says, my recollection is there were valuations, of course, but there was no valuation under the terms of the shareholders' agreement, is my recollection of that. So I could be wrong because it has been a while since I heard it. It had been about 5 to 6 weeks. And my learned junior makes clear that the defendant said that the valuations were valuations of the shares under the provisions of the shareholders' agreement. And he explains that a bit further at letter B on page 126. And when one comes to the judgment on interest, and that's page 142 of the core bundle, it is in our submission clear that the judge simply misremembered, misunderstood the basis on which he had decided the claim. So in paragraph 2, page 142, he says, as explained in the judgment handed down, this case proceeded before me on the basis, as accepted by the defendant, that the claimant was entitled to be paid for the shares which he was required to sell under the terms of a shareholders' agreement made in 2006. That's more like it. That's more accurate. It was accepted that he was entitled to be paid. And then he says it is accepted that the terms of the shareholders' agreement were not complied with. Not only was the claimant not paid for the shares, but they were converted by the defendant by the removal of his name from the share register and by their transfer to others. Now, that's simply wrong. There's no such acceptance. Big dispute on the pleadings, not resolved by the judge. Conversion claim struck out. As a result, next sentence, the circumstances of the breach of the agreement concerning the requisite valuation and payment and of the conversion were not the subject of investigation at trial. Now, the judge is right that the circumstances which were alleged to amount to breach of the shareholders' agreement were not investigated at trial. That's because they were academic and didn't really matter, not because the defendant accepted that they were all true. We have the ruling on interest and on section 35 of the Senior Courts Act at paragraphs 5 to 6.
Mr. Coppell, are you now on the second of your 4 topics?
I'm sorry, I did. I've gone on to the judgments, the judgment of the court, I should have said when I first referred you to paragraph 2.
Yeah.
This is the second of my topics. The ruling on interest, paragraphs 5 to 6, the judge said there hadn't been sufficient argument analysing whether it's a claim in debt or damages. I'm sorry, I should say he says first of all in paragraph 5, in the first sentence he refers to the plea of conversion of the shares. He then says it was subsequently amended, but no one has suggested anything turns upon that. Well, a lot did turn upon that because the plea of conversion was struck out. He'd actually been told that by my learned friend during the trial. No sufficient argument analysing whether it's debt or damages. He says because from the party's perspective there did not need to be. And he says in the final sentence, this is a case where the defendant has accepted that the price has to be paid without the need for share transfers because of the conversion of the shares by the defendant, treating the claimant's obligation of transfer under the shareholders' agreement as fulfilled. And what one sees is repeated reference to the defendant having converted shares. And that does seem to be the primary basis for the judge's ruling on interest, that this was a claim for damages for conversion. We've seen that in paragraph 2, paragraph 5, paragraph 6. He says at the end of the paragraph, it is clear the court has a discretion to award interest under section 35A in those circumstances of non-payment of a contractual liability and of conversion of the shares, and when the claim proceeds to trial in the manner of accepted fact, as previously summarised. Well, that hadn't proceeded in the manner of accepted fact. reference to conversion, further references to conversion in paragraphs 7, 15 and 17.
Sorry, can we just go back to paragraph 6, please?
Yes.
He expresses himself in terms of conversion, certainly, but that's the second of the points he makes. The first is non-payment of a contractual liability.
Yes.
Now, so far as conversion is concerned, if the conversion claim had not been struck out, would you accept that there would have been an extant claim for damages for conversion? But there wasn't. But there wasn't. But in fact, there wasn't, you say.
Yes.
So, but if one, as it were, deleted that reference to conversion, what's your submission about the earlier part of his judgment, about non-payment of a contractual liability?
Yes. So Lord, I say that this is not and never was a claim for debt, and I will come on to explain it in more detail why that is so.
Yes.
In effect, the claim was not for an ascertained liability fixed by the contract.
Yes.
What had happened was the defendant had, it was alleged, failed to operate a process whereby a third party would make a valuation and then pay a price.
I see.
But that, for reasons that I'll come on to in a bit more detail in due course, is not a claim for debt. We
Yes, I see.
within section 35A. What the claim was in effect was for specific performance requiring the defendant to operate the agreement. Now, I'm simply trying to identify what was the judge's predominant thinking under section 35A. I accept he does refer to non-payment of the contractual liability, which probably was a reference to debt. It's hard to be certain. But his predominant thinking, it is clear in our submission, is conversion. And that appears throughout. And it also appears in his refusal of permission to appeal on this point on page 194, where he describes the 21,188 as a sum in damages for the payment.
Sorry, which page was that?
194.
Thank you.
A sum in damages for the payment that ought to have been made for the shares. Now, going back to the interest judgment, the judge does go on in paragraphs 8 to 12, and in particular in paragraphs 10 to 11, to recognise that there had been disputes that he hadn't been required to decide at the trial. And not all of which we say are fairly characterised. Paragraph 12, it becomes important, where the judge concludes that he has to make a ruling on interest, and it's the final sentence of para 12, from the basis that the valuation required under the terms of the shareholders' agreement never took place. So he's been asked to bear in mind that the claimant's been offered £32,000 and then £24,000. Claimant says, well, those weren't valuations done under the shareholders' agreement. That wasn't decided at trial, but the judge proceeds from the basis that the claimant was right about that. And we say that was unfair. The claimant made an allegation of breach of the shareholders' agreement, which he then chose not to pursue at the trial. He bore the burden of proof on that allegation, and yet the defendant is then disadvantaged when it comes to a ruling on interest by the court never having decided the claim which the claimant did not pursue. Interest awarded under section 35A, and I'll come back to the grounds in a little while, and the order is at page 65 of the bundle. Paragraph 3 on page 65, the claimant shall be paid 21,188 shares. Interest is payable from the 4th of November 2011. There's a discrepancy between the order and the judgment, where interest is ordered in the judge's reasons at paragraph 15. There is a ruling that interest shall be ordered from the 18th of April 2009, so that's the date of the expulsion. What the judge had actually ordered was interest from the November 2011 date, which was the date of the transfer of the shares. But when he came to write up his approved reasons, he had lost sight of the order that he had made.
So was the order made before he perfected the judgment?
That's right. That's right. There was an extemporary judgment, then an order, and then the perfected judgment. Nothing turns on that. I just wanted to explain the discrepancy. The judge's view that the defendant had breached the shareholders' agreement, and indeed that he had decided that, had solidified yet further when it came to the costs hearing, which was on the 12th of August 2022. Page 155 of the core bundle. At letter E to F, there's an exchange with my learned friend where the judge opines that the shares could not have been valued other than pursuant to the shareholders' agreement, which just did not occur. My learned friend gratefully agrees. 162 at letter F, in exchanges with my learned junior. I'm sorry, letter F to G. The judge, referring to the claimant at letter G, says they had to come to this court in order to get a decision in circumstances where your side had breached the terms of the shareholders' agreement. Your side were the only people who could provide a valuation, had not provided a valuation. Claimant needed to come to court, etc. And 163, my learned junior again points out that the defendant simply didn't accept that there had been any breach of the shareholders' agreement, that the accountant was the auditor for these purposes. And then at letter B, the judge says, we dealt with that at the hearing and we decided all that as hopeless. I mean, you're just repeating what you lost at the previous hearing on this. And then at 186, my learned friend is involved in exchanges with the judge, where the judge appears, at least from the transcript, to be quite irate. Starting at letter E, again on the issue of whether the shareholders' agreement had been complied with. The judge says, you had not carried out the shareholders' agreement. We disagree with that, my lord. No, you do not, because you came to this court. I'm sorry, you have to be honest to the court. And then going over the page to 180.
Well, just before you leave page 186, the judge goes on to say, no, do not interrupt me. This is very serious in your position as a barrister. You cannot come to court and put forward arguments that don't reflect the circumstances.
Yes, I'm sure that indeed it does get worse. My learned friend is effectively accusing misconduct by the judge for persisting in making the point that the issue of breach of the shareholders' agreement had never been determined against the defendants.
Obviously, we can all have a failure of recollection, but certainly the way in which the point appears to be being expressed is that you're not entitled to make this submission.
That's right, and you're not being honest.
And he goes even further on 187. I'm quite appalled by your conduct.
Yes.
Completely unacceptable for counsel to come to court and make submissions which have no basis in law or fact. I mean, I know it's a transcript, and it's difficult to recreate atmosphere from a transcript. It doesn't read attractively, I have to say.
No, Lord, it doesn't. And we say that the judge's evident unfounded irritation with the defendant is then borne out in his judgment on costs. Which begins at 188. And paragraph 3, he says the position concerning costs, subject to considering the offers, turns out to be relatively straightforward. The claimant was the successful party to the extent that he obtained an order for payment of sums due for the transfer of his shares resulting from his deemed transfer notice of April 2009. And there's reference in the following sentence. The fundamental factual position was the defendant unilaterally transferred the claimant's shares and removed him as a member without his consent. At least a hint of wrongdoing by the defendant there. But what we say on that paragraph is it's simply wrong to say that the claimant was the successful party because he obtained an order for the payment of sums due. It had never been in dispute from 2009, 2010 that the claimant was entitled to payment for his shares. The only thing that was in dispute when it came to the trial was how much he should be paid. And he lost that argument. Various other claims, conversion, partnership capital, had all fallen by the wayside. What was left was how much he should be paid, and he lost. And that's recognised by the judge in paragraph 4.
Sorry, before you leave paragraph 3, can I just note the point you read out in the middle of that paragraph, that the defendant had removed the claimant as a member without his consent? As I recall, in 2010 there had been a judgment by Judge Dyke, which had a bearing on that.
Yes, that's right. There was a challenge to the claimant's expulsion from the partnership, which was resolved in favour of the partnership, the other partners. Then there was the issue of the claimant's membership of the company, where he was required to sell his shares under the terms of the shareholders' agreement. But but it's all
I see.
it's all presented as, well, this was done unilaterally without his consent. Yeah. Well, no, this was done pursuant to the agreement that he'd signed.
So it is correct, as a matter of fact, to say that he was removed as a member of the company.
Yes.
But your point is that that was not an unlawful removal because it was pursuant to the shareholders' agreement.
Well, yes, my lord, that's our case. But just to be clear, I'm not inviting the court today to decide whether we complied with the shareholders' agreement in full or not.
No.
You can't decide that. The judge didn't hear the evidence about it. He didn't decide it.
That's your point, that he didn't decide it.
He didn't decide it.
Because he had said that it wasn't necessary to decide it. And that's how you get on to your point. The real point is that the only dispute at trial was how much were they worth.
Yes.
Right. Thank you.
Being fair to the judge, he does recognise the claimant lost at the issues at trial. That's paragraph 4. And going over the page, paragraphs 8 and 9, the judge decides that the claimant should get credit for having won the argument on interest. And that's the end of paragraph 9. I'm sorry, I've skipped over a paragraph. I should say paragraph 6 is the consequence of the reasons that the claimant is successful in the proceedings but not at trial, is paragraph 6 that the claimant gets his costs down to the expiry of a reasonable time after the expert's report. That's the starting point. Then paragraph 9, that's adjusted, whereby the claimant has to pay 1/2 day of the trial costs to the claimant to reflect the claimant's success on interest. And the judge then considers certain of the offers that were made to the claimant over the years, and his reasoning for not accepting the offers include, see paragraph 13. He says, I would also add a critical matter which I consider to be relevant in the exercise of my discretion, which must be borne in mind, that there was a unilateral conversion of the shares. This was certainly unacceptable conduct. I've taken this into consideration in the decisions already made. And what are the decisions already made? The decision that the claimant gets his costs up to the point of the expert's report. But also a matter which falls to be weighed in the balance when deciding that this letter should not affect the order or costs. And a later offer, the call to bank offer, is rejected as relevant, paragraph 15. Again, there's reference to the problems of a unilateral conversion of the shares and all the claimant not being in a position to value the shares himself. And he then goes on to require the defendant to pay 50% of the claimant's costs of the costs hearing. And the costs order, drawing all that together, is at page 66.
Yes.
Part 3 then of my submissions, and I'll go relatively quickly now, grounds of appeal in relation to interest. And it's paragraph 23 of my skeleton argument. Ground 1 is that the judge, in making his ruling on interest, proceeded on the basis of incorrect and unfair factual and legal findings. And these findings are set out in A, B, C and D of paragraph 23, and they are essentially breach of the shareholders' agreement, conversion, all assumed by the judge to be correct when it comes to making his ruling on interest. And that is that ultimately we say is the explanation for how the judge is able to find that he has jurisdiction to award interest, because he thinks he's awarding damages for conversion, alternatively damages for breach of contract. That's the breach of the contractual liability point you referred me to in that paragraph. So he thinks that there has been conversion and breach of contract, but those issues were never decided, and in the case of conversion had been struck out long before trial. And the exercise of any discretion under section 35A, we say, is also polluted by this indisposition, to put it mildly, towards the defendant. So ground 2 then is the section 35A point. And that's paragraph 24 of my skeleton argument. And you have section 35A in the bundle of authorities at tab 1. Subject to rules of court in proceedings before the High Court for the recovery of a debt or damages, and may be included in any sum for which judgment is given simple interest at such rate as the court thinks fit. Now, as you know, we say this was not a claim for damages. Conversion claim struck out, so not a claim for damages in tort, and nor was it a claim for damages for breach of contract. There was never any plea of damages for breach of contract. Can I just take you back to the relief sought in the amended particulars of claim at 215? There is no claim for that. There never was a claim for relief for damages for breach of contract, whether liquidated or unliquidated. What there was a claim for an order that the procedure in the shareholders' agreement be operated. Claimant paid the ascertained value. Had there been a claim for damages for breach of contract, that claim would have been time barred, just as the claim for conversion was time barred.
Do you submit that when we read subparagraph 2, you can't read the "and" as being disjunctive? In other words, what's being sought is a composite order. First, that the shares be valued pursuant to the agreement, and then whatever that ascertained value turns out to be, at that stage, the monies be paid. Is that how you put it?
Yes, yes, it is a composite order, and it's composite because it's asking for the 11.4.4 procedure to be implemented, and that procedure involves valuation and payment.
Right.
Never any dispute about that.
And that would be, I mean, all of that is framed in terms of what ought to be done in compliance with the shareholders' agreement. So I think what you're also saying is that, is this right, that part of the relief sought is not claiming damages for breach of contract.
Exactly, it's asking that the contract be complied with.
Right.
And that's why you say it's effectively a claim for specific performance.
Yes.
I mean, could another way of looking at it be to say it is a claim for a contingent debt? The contingency being going through the machinery laid down in 4.4, and then the debt being the obligation to pay over the money as a result. I mean, it's only a jurisdiction point, you know, so on the face of it, it seems perhaps a little odd if there's no jurisdiction at all to award interest in a case of this type, where for whatever reason, and if whoever is to blame for this, the claimant has actually been has not received the money to which he was entitled, and which has been set aside in an account earmarked for him for what, over a decade now. I mean, it's new.
Well, we would say that it's not a debt, or,
No.
or indeed a contingent debt claim. A debt,
Yeah.
perhaps I could show you the, I do have one additional authority which I thought might be necessary, just to show you what a limited learning there is on the definition of a debt for these purposes.
Is this the case that Mr. Justice Brandon decided? I saw, I mean, looking through the one case we did have in the bundle, I saw a quotation there from, I think it was, which seemed to me might be of some help on an area where I might expect to find there's quite a lot of authority, although there seems to be absolutely next to nothing.
So, yes. So my lord is referring
Thank
to
you.
BP and Hunt.
Yeah, sorry, I'll try and find what I was referring to. It
I
was,
think it's the Aldora.
no, it's the Eldora, that's right, yes.
So there's,
No,
I think you're referring to paragraph 19 on page 10 of the authorities bundle.
yes, beg your pardon, that's right.
Yes, sorry.
Indeed,
sorry,
the Eldora,
Eldora,
yes,
indeed.
yeah.
I'm sorry, it was Lord Brandon in BP. Brandon J. and the
I see.
Eldora.
Yes, so it was, yes, I see. Same judge, just become a law lord, but we've got time we get to BP and Hunt.
Yes. So, Lord, I had looked through the various authorities on the predecessor to Section 35A, which included BP and Hunt, and didn't think that there was anything to which I needed to draw the court's attention. One can see from paragraph 19 that Section 35A is to be determined, is to be interpreted fairly broadly. I don't dispute that.
I take it you don't disagree with that. I mean, common sense would suggest.
So simply on what is a debt, and this is a case about landlord's cost of repairing property. And Lord Justice Millis at page 202 at letter G. I'm quoting Chitty, a debt is a definite sum of money fixed by the agreement of the parties as payable by one party to the other in return for the performance of a specified obligation or on the occurrence of some specified event or condition, whereas damages may be claimed from a party who's broken its primary contractual obligation some way other than by failure to pay such a debt.
So why doesn't the payment of the price of the shares here come within the first limb of that? Because it appears to be on the occurrence of some specified event or condition.
Well, because the obligation to pay and the amount to be paid is not determined or indeed determinable simply by the event of the claimant leaving the practice. There has to be the invocation of a procedure whereby a third party is instructed to value the shares.
That's the bit I'm not understanding, I'm afraid, Mr. Coppell. Why is that not, that valuation by a third party, why cannot that be said to be the occurrence of some specified event or condition?
Well, I mean, we say that what the specified event in this case is the claimant leaving the partnership. That creates the obligation to sell his shares. He is then entitled to be paid for the shares, but the process of ascertaining what he is to be paid involves, as I said, the appointment of a third party, and it's simply not ascertainable at any point prior to the third party, the auditor, making the valuation in accordance with the shareholders' agreement. And what the claim was in this case was that the defendant simply had not implemented the procedure properly, which we say would be either a claim for damages, which wasn't brought, or there's a claim to require the defendant to implement.
So this is why your first two grounds are linked, because as I understand it, what you're saying is the position might, you don't accept it necessarily would, you say it might have been different if the claimant had pursued his claim for breach of the shareholders' agreement and there had been a finding of breach. Because in those circumstances you say, well, possibly you could say that's a debt, but you say claimant didn't pursue the claim for breach of the shareholders' agreement, still less was there any finding of a breach, and absent any breach, how can there be a debt, you say?
Yes, that's right. And I do say that, and I also say, and there's some other complexities to this, I also say, in addition, how can there be a debt when, first of all, the obligation to pay is only triggered under the shareholders' agreement by the provision of share certificates? That's when
And he never provided the certificate.
which he hasn't yet ever provided, even to this day provided. So one can understand a claim to make the defendant go through the procedure, but the argument that the defendant had breached shareholders' agreement in such a way as to create a debt, that can't be right when the obligation to pay had not yet arisen.
That's an important point. Can we just go quickly back to the shareholders' agreement just to look at that? I know you took us to it earlier.
Yes, so that is on page 248.
Yeah. So in other words, what you're relying upon here, as I understand it, is the last sentence of 11.4.4.
That's right.
And you say, until he shall deliver up his certificate or certificates of the remnant shares of the company, when he shall thereupon be paid the purchase money. So as I understand it, what you're just submitting is the effect of the word thereupon is there's no obligation to be paid unless and until he delivers up certificates.
Yes. And again, one could perfectly understand a claim you the defendant haven't carried through this procedure as you should have done, and that's why I haven't given you my share certificates. So there's a claim of breach of contract and a claim for damages. One can understand that, but there is no debt. There is no obligation to pay until the share certificates are provided. And the other complexity or additional point that I mentioned is the judge's analysis that the parties had agreed to vary the shareholders' agreement 11.4.4 and the definition of transfer price so that the transfer price would be determined by the court. I said that was a point that was open to different analyses, but that's what the judge decided as far as it was relevant. So it's no longer being said by the claimant, you need to go through this procedure. It's saying, I want a different procedure. We'll get the court to tell us what the value is, assisted by Ms. Hart. And at that point, I'll give you my certificates and you can pay it. Again, where there's an agreed variation and a different method of valuation, which hasn't yet taken place because the court hasn't yet ruled, how can there be a debt?
So, okay, let me see if I've understood that submission correctly. So this is an independent point from the one you made by reference to 11.4.4.
Yep.
So you say the judge rightly, I think you say, or at any rate it's unchallenged. It's unchallenged that the judge said that what the parties had done was tantamount to a variation of the shareholders' agreement, whereby instead of the contractual machinery, they substituted a machinery of valuation by the court on the basis of a single joint expert report. And therefore, given that variation, it can't be said there was any debt.
Yes.
Do I understand you correctly?
Yes, because the parties had agreed that the valuation was to take place in the future by the court. Not that it should have happened in the past, it's to take place in the future.
But isn't the valuation that they've in effect agreed should now take place a valuation of what the shares were worth?
Yes.
And therefore what the price should have been when it was payable?
It certainly is a valuation of what the shares were worth at the relevant time, which was the date of expulsion,
Well,
according to the judge.
well, query what the exact date was, but would you at least accept that it could be a date in the past rather than a date in the future?
Well, yes. Sorry. I didn't make myself clear. Absolutely, the exercise is to value what the shares were worth at a past date. In this case, it was April 2009.
Yeah.
But the variation to the shareholders' agreement was that valuation should take place in the future by the court.
No, I understand that.
So
the event of the valuation taking place is, of course, going to take place in the future. But once that has taken place, don't you have to ask yourself the question, what has been valued? And isn't that the price that should have been paid at some point in the past? And we can debate about when that would have been, but
well, it's the
price that should have been paid.
It's the should have been, which is difficult,
Right.
because the parties have agreed for some different mechanism as to how the shares should be valued in the future by the court.
So can I think aloud a little bit about that point? So the judges suppose that there's a variation, but the variation that he's postulated and proceeded on the basis of is regard to the machinery of valuation, not the machinery of payment. So the only payment machinery remains that specified in the shareholders' agreement, viz. The claimant gets his money when he delivers up his certificate.
That's right.
Is that correct?
That's correct. So strictly, what is being varied is the definition of transfer price on 243, not 11.4.4, not the the mechanism for payment, etc. So it's really then I come back to the same point. Where is the debt? How could there be a debt? How could the defendant owe the claimant money before the court has made its ruling?
But doesn't this show it's 1 point, not 2? Because whatever the machinery of valuation, whether it be the contractual machinery or the court machinery, the point as to whether there's a debt or not is really the same. Namely, you've got to look at the machinery for payment.
It's the same point with two sub points. Yes.
And that point is what? That there's crucial requirement that he had to deliver up the certificate.
The point is that the time for payment had not yet occurred either because he hadn't delivered the share certificates or because the valuation machinery as amended, as varied, had not run its course.
Yes.
Because the court was going to decide.
Yeah, all I'm suggesting to you, Mr. Coppell, is that I don't think you need the second of those. And you may not, speaking for myself, you may not necessarily be right about the second of those. What seems to me, at least at the moment, subject to hearing the respondent's submissions, is critical to your argument, is that there was a contractual requirement that you had to deliver up the certificate. And that, on any view, had never occurred. Is that right?
Yes.
Now, you were showing us Jervis and Harris. Was there anything else in that?
I think the only other bit of that judgment I wanted to show you is at 203 at letter A.
Thank you.
Lord Justice Millett said it's not necessary that the amount of the debt should be ascertained at the date of the contract. It is sufficient if it is ascertainable when payment is due. And I made my submissions as to whether the amount was ascertainable when it depended upon the commencement of a procedure involving appointment of a third party.
Yeah, but then the reasoning that follows is germane. It says the landlord's monetary claim under clause 210 does not arise unless and until he's carried out the repairs. When it does arise, his claim is for an accountant payment, not for damages. So maybe there's a debt at that stage, but not damages.
Yes, there's a debt. You don't know when you sign your lease how much money the landlord's going to spend repairing your property, but once he's spent it, there is a debt.
Yeah.
We say that's different from this third party procedure which is contemplated here.
Right.
And sorry, just before we go on, would you also perhaps say we need to guard ourselves against the risk of being seduced by an argument along the lines that since the valuation is as at a date in 2010, therefore when it's been performed, we should, as it were, jump to the conclusion that ergo there was a debt actually payable as at 2010 upon which interest can run, whereas the machinery for payment remains that set out in the shareholders' agreement itself, and until those steps have been gone through, no debt arises, and therefore nothing upon which interest can bite.
Yes.
And if anything, one gets perhaps reinforcement for that in the provision that until the determination is made, either by the contractually agreed machinery or by an agreed variation, the money is sitting in an account and held on trust for the claimant, but expressly without interest.
Yes, I do say that.
Yeah.
I do say that. Thank you. So I submit the reason I rely on the Odyssey case, apart from it being the only authority, section 35A, the reason I rely on it is for the short point at paragraph 17, page 9 of the authorities bundle, that section 35A cannot be read as encompassing any claim whose ultimate purpose is the recovery of money from a third party. So judge says it's possible it could be read as encompassing any claim whose ultimate purpose is the recovery of money from a third party, but then it's difficult to understand why it's couched in terms of debt or damages. So no dispute in our case that the ultimate objective of the claim is to obtain a payment from the defendant. But my distinction between a claim for an order for specific performance of the machinery and a claim in debt or damages is not a technical one, it's a real one in the circumstances of this case.
And that, I think, if I've understood your submission correctly, that perhaps comes back to my Lord's point a moment ago, that timing can be important. Because the underlying rationale, as I understand it, of the requirement to pay interest is that somebody's being kept out of their money. And your point, I think, is that if a contractual agreement sets up a machinery for, in due course, ascertaining what money should be paid, it's only, as a matter of timing, it's only at that point that it could be said that there's a debt. Not back in 2010 or 2011.
Yes, absolutely. And a lot of course, if you could claim against a defendant, well, you've obstructed the process, you've prevented it from running its course. That's why I haven't provided my shares to you. Well, that's a claim for damages.
Yeah, and that would be damages for breach of contract.
Yes.
Right.
But that claim was never made, or wasn't. It wasn't. Well, it was never made as a in this case.
Right. Thank you. So is that all on Odyssey?
So that's all on Odyssey.
Yeah.
I think I only have a couple of additional points on interest, but I would endorse what's been put to me about the dangers of assuming that just because the valuation was in the past, that therefore a debt has been created. The valuation proceeds with reference to a date in the past, therefore a debt is created in the past. But one understands why the judge proceeded on that basis himself, because he thought the defendant had breached the contract, breached the shareholders' agreement in the past, wrongly as it happened. But that's perhaps explains his reason. So my ground 3 is the period over which interest is ordered to be paid, and really one overlaps really quite heavily with points I've already made in relation to ground 2. Essentially, cause of action not yet arisen. Claimant had been offered the money several times in the past.
Yes. May I ask you this, Mr. Coppell? Does ground 3 have any independent viability, or does it depend on at least ground 2 succeeding?
Well, it doesn't depend on ground 2 succeeding in the sense that ground 2 is a jurisdictional point, whereas ground 3 is really goes to the exercise of discretion, assuming there is a jurisdiction. But in substance, I'm making similar sorts of points. How can you order interest on the basis that the claimant has been kept out of his money when the obligation to pay hasn't yet arisen, the course of action hasn't yet accrued, and the claimant's been offered all this money?
So these are alternative ways of packaging the same argument. The first way of packaging it is no jurisdiction. The second way of packaging it is no basis for exercising the discretion.
Yes.
Right.
And insofar as I need to show a ground for challenging the judge's exercise of discretion as opposed to jurisdiction, then that is ground 1. That's because he was proceeding on the basis of incorrect assumptions.
Yeah.
So then I come to part 4 of my submissions on costs, and standing back, and one doesn't often stand before this court arguing about a costs ruling of a lower court, but what has happened in this case, where very substantial legal costs have been spent by the claimant, is what's happened is that the vast majority of the claims failed before the trial. They were either struck out or discontinued. And the defendant succeeded on the only issue which was actually decided at the trial, which was that of the valuation of the shares. And the ultimate result is that the shares were to be valued at a price significantly lower than the claimant had been offered in 2010, 2011 and thenceforth. But yet the defendant is left with a substantial costs liability towards the claimant. All of the costs of the claim up until the expert, the date or shortly after the expert report of Ms. Hart, and in addition paying the claimant's costs of half day of the trial and of the costs and some of the cost hearing as well. Now we don't know exactly how much that's likely to be, but it's a substantial liability in a case where the claimant has failed on everything. Everything that's ever in dispute. The claimant cannot point to a single claim which has been upheld. Now, how does that translate into grounds of appeal? Essentially, that is ground 8, which is the ultimate result arrived at by the judge was outside the range of reasonable disagreement. It's simply no justification for ordering the defendant to pay any of the claimant's costs, and certainly not the very substantial costs which were ordered. And the problems, we say, arise from essentially paragraph 3 of the cost judgment on page 189, which is the point made by the judge that the claimant was the successful party to the extent that he obtained an order for payment of sums due for the transfer of his shares resulting from his deemed transfer notice. Never in dispute that he was entitled to payment. Given that it was never in dispute that he was entitled to payment, and the valuation that he got at the end of the day was not what he was arguing for and was less than he'd been offered all along, there was simply no need for the proceedings to have been issued. One can go back to the September 2010, the September 2010 letter, £32,000, and the subsequent offers of £24,000. Certainly no justification for spending hundreds of thousands of pounds pursuing the defendant to trial. And secondly, where has the judge gone wrong? Where has he stepped outside the range of reasonable disagreement? It's in his costs orders being informed by his negative perception of conduct of the defendant, and indeed of my learned friend to the extent that was totally unjustified. So that's ground 8. Ground 7, that's my skeleton argument at paragraph 38. The The judge discounted, as you've seen, certain of the offers which were made by the defendant over the years, starting in 2010. And he did so largely because he regarded, you say quite wrongly and unfairly, he regarded the defendant's offers as not being in compliance with the shareholders' agreement. We say there was simply no warrant for dismissing the relevance of the various offers made on grounds of the defendant's conduct. And again, standing back, the claimant recovered by way of valuation of the shares substantially less than he was offered in September 2010 and less than he was offered in 2011, 2016, 2017, 2019, 2020, 2021. It seems bizarre with respect to the judge that the defendant is left with a substantial cost bill against that background. And I know, and I'm sure you'll hear from my learned friend, there are all sorts of arguments about this offer didn't say this and it didn't comply with that and it wasn't the other. But as a matter of substance, it is bizarre that the defendant is left with a substantial cost liability at the end of this case. There are then points of detail in my grounds for concerns the hearing on interest. If you're with me on interest, then the defendant should not have been ordered to pay the costs of the hearing on interest. And if you're with me to a sufficient extent on the costs arguments, then the defendant should not have been ordered to pay the costs of the costs hearing. And that then leaves ground 5, which is at paragraph 34 of my skeleton argument, and I'm not pursuing this ground.
Sorry, which one?
Ground 5.
All right.
So we had submitted that the defendant had been left with some costs of claims that had been struck out, but I'm not satisfied that that's an accurate representation, in fact, of what occurred. So I'm not
all right.
pursuing that ground.
That's very helpful, but Mr. Copper, does that have any knock-on effect on what you said at the very end of your skeleton argument about what the costs order should have been? Because what you were claiming at the end of the skeleton argument, paragraph 41, was in the case of the costs order, it should be replaced by an order that the claimant pay the defendant's costs of the proceedings.
That doesn't affect that because the reason I'm not pursuing ground 5 is because I'm accepting that the claimant has already paid some of the costs of the proceedings, i.e. or at least he's been held liable for some of the costs of the proceedings, i.e. the struck out claims. And I maintain that the claimant should pay the remainder of the costs of the proceedings.
I see. Thank you very much.
So just as the judge's order was qualified by any previous cost orders in the proceedings, so would yours.
Thank you.
Those are my submissions, unless I can do any further assistance.
Can I just check if my lords have any questions? No, thank you very much. Yes, Mr. Dillon.
My lord, the order I would seek to do is to perhaps deal with some general factual points or correctures that I put in that would assist your lordships. And then my roadmap was to essentially respond to each ground as has been pleaded against the respondent, going through grounds 1 through to 9, excluding 5, which I understood has been withdrawn. And earlier was put by your lordship whether it's agreed between the parties that Hubbard Lloyd were not auditors. And I think, just to be clear, I think your lordship went on to say whether it was agreed that auditors are not required under the transfer, under the shareholders' agreement to value the shares. That part is not agreed between the parties. The respondent's position is that an auditor was required under the transfer, under the provision, for the purposes of determining the transfer price under the shareholders' agreement. If any support is required, then I'll take my submissions very shortly in that regard, that an auditor was required. We say, submission of this, firstly, page 244, clause 4.3. The word, the auditors of the company shall be, the capitalisation, as your lordship identified, is not within the definition, but in my submission it should be given its natural meaning, in that the parties have agreed that this company will have an auditor in addition to an accountant. And I say that when one looks at clause 5.1, concerning the conduct of the company's business, at clause 5.1.6, it's clear, it says the company shall prepare its management and audited accounts on a historical cost basis and shall adopt such accounting policies and practices as may time to time be generally accepted. So there's reference to both management and audited accounts, and at 5.1.7 says the company shall prepare accounts in respect of each accounting reference period as are required by statute. Page 245. And then it says, towards the end of the sentence, it says that the end of the relevant accounting reference periods, and crucially that such accounts are audited no later than 8 months after the relevant accounting reference period. So my submission there is that auditors were required, and it's a point that I canvassed with the learned judge in my submissions to him, which I will take your lordship through later.
So you say it was a contractual obligation, even if not a legal one, that this particular company should have auditors?
Yes. Yes, Lord.
Yes. I see.
If context is required for that, this was a company which was interlinked to the partnership. It is unfortunate that the first morning's transcript, the transcript of the morning is unavailable, but one of the 12 factual points I raised, as agreed with Mr. Ojo who appeared, is that that this was a company was in fact a quasi partnership. And just for background, that arises as the purpose of the company was to hold a property which was leased to the partnership, and then the partnership would be reimbursed by the NHS cost rent scheme. So in my submission, with that in the background, it is understandable why the shareholders would agree, where one is receiving reimbursement from effectively the NHS for the leasing and improvement of the premises, why there would need to be separate auditors.
But in fact, the normal thing with a small company of this nature, if you do have auditors at all, would be to appoint the accountants to be auditors as well, wouldn't it? I mean, that was the position when Kingston Smith, they were both the accountants and the auditors, as I understand it. Is that wrong?
They were certainly appointed as the accountants. Whether in the history of this company, no accounts were ever audited, so Kingston Smith never produced any audited So, my lord, I think that's none were.
The shareholders' agreement was that the auditors of the company shall be Kingston Smith.
Yes.
So in that case, they were basically saying that the firm of accountants, or perhaps one could imply for that whoever the company employs to be its accountants should also take on the duties of being auditors as well.
That would appear to be on the face of the document, yes.
So in that case, when, I'm sorry, I've forgotten their name now, when the replacement took place,
Yes.
I mean, they were on any view appointed to be the company's accountants. There's a lengthy letter of engagement as one would expect.
Yes.
But it goes out of its way to say we're not actually acting as auditors.
Yes. So
where does that leave us?
well, my lord, I'll deal with that in this way, in that whilst it said that they were, Hubbard Lloyd were the
Yes.
subsequent accountants,
Yes, that's right. Yes.
they had been appointed, and there was, I'm trying to recall from the minutes, but I'm not sure it's clear that they were appointed as the auditors as well as the accountants, because they don't have the capacity to be the auditors.
I thought, I may have misremembered, they went out of their way to make it clear that they were not acting as auditors.
Yes. So although they were appointed,
Yes.
they could have only been appointed as accountants. They didn't have the capacity to be appointed as auditors.
I'm not quite sure what you mean by didn't have the capacity. I mean, it's just a matter of contract, isn't it? They must have been used to acting as auditors, I would imagine, as a firm of accountants dealing with small companies like.
Forgive me, my lord, my understanding is that Hubbard Lloyd were not qualified as auditors to undertake an audit.
I see. Well,
And so therefore, in this case, it would have been necessary to appoint auditors.
but since the shareholders had agreed on the appointment of the replacement firm, can it be perhaps implied then that they must have agreed effectively to waive the requirement that they should be auditors as well?
My lord, I say that that is a point which is I would say, well, not necessarily, no.
It just, I mean, all right. The logic of your client's case is that what this company had to do before he could be properly paid out was appoint a separate firm of accountants to act as auditors, which would have involved a lot of extra expense. But and it's at the moment seems like an insistence on a formality which would only just add to the overall cost of the exercise, with no tangible benefit as well.
It was the same question was put to me by His Lordship below,
Yes.
and my answer to that was that firstly the context that it's a quasi company that's linked. Sorry, that obviously has to be considered with the partnership that had substantial income. So it wasn't just a standalone property investment.
Oh yes.
A special
Yes.
a special investment company. Special investment vehicle. The second point is that. So one point is quasi. The second point is that it is, as I said, with the backdrop of receiving reimbursement subject to a statutory scheme from NHS England. So it would make sense to have the need to have auditing of the accounts. The third point, which I was unable to pursue because the pleading was not allowed to be amended, is that when disclosure occurred in late November, it was clear that there were inconsistencies between the lease itself and income into the company. And so my point here and below is that had the auditors, had the accounts been audited, these are the matters that would have been properly looked at and corrected, such that when it came to determining a transfer price and the mechanism, the transfer price for this type of arrangement is properly done on audited accounts rather than traditional accounting procedure.
But as you say, you didn't get permission to amend to raise that.
Correct.
Yeah.
Thank you.
Right, so I think we understand your point about that particular factual aspect of the appeal.
The other factual matter is, so it is clear at the outset, is the Lordship have heard much about the valuation in 2011, which was done 30th of March 2011 by Hubbard Lloyd. That is found at page 20. Page 21. Sorry, page 20 is the first page of the supplementary bundle.
Yes, thank you.
It's dated the 30th of March 2011. The Lloyds, at page 22, they set out the information provided for the purpose of the valuation. And at 3E, they referred to the Ruth Sutherland Co. informal note. And then crucially at page 24, paragraph 5, clause 5, under valuation of the whole company, the third paragraph reads, accordingly, and in view of Ruth Sutherland Co. being experts in the valuation of company shares, it is appropriate to follow their basis of valuation as set out in their informal note. For a property investment company is commenced with the net asset value shown in the company accounts, to which the following possible adjustments would have to be made. So they rely significantly on Ruth Sutherland, as Ruth Sutherland being the experts. The difficulty with this being a compliant valuation is that when one turns to the Ruth Sutherland informal note, page 68 of the supplementary bundle, at 1.3 on page 68, it's clear that Ruth Sutherland statement you have accepted is emphasised by us that we are not preparing this note under the provision of the shareholders agreement between all the shareholders of the company itself. The relevant provision is set out clause 1.1. We are not acting as the auditor, and nor are we acting as an expert or certifying the fair market value of the shares. So the proposition is that neither the Ruth Sutherland note is clearly not appropriate as being a valuation of the transfer pricing mechanism of the shareholders agreement, and nor is the Hubbard Lloyd valuation, because they make it clear they're relying on following the same procedure. In addition, the Hubbard Lloyd valuation on the 30th of March 2011, so it's clear, it was not disclosed to the claimant until the 4th of January 2017. I'll take you to the correspondence there. That is found at page 37 of the supplementary bundle. We have a letter dated the 4th of January 2017 from the first defendant. Page 38. The second paragraph beginning, please find enclosed statement. Sorry, if I may just read. Please find enclosed the valuation report from David Hubbard, which we believed was sent to your client at the time. The response to that is at page 54. A letter from those who instruct me, dated the 2nd of March 17, and at page 55, second paragraph again, stated you refer to a valuation by Hubbard Lloyd, enclose a copy of the report attached to a letter. And crucially, I have not seen this report or the covering letter before. The only document I've seen is the informal note of Frew, Sutherland & Co. of 13th of October 2010. In the early months of my involvement in the case, I asked your partner to send me a copy of the letter. So that valuation was not disclosed until very late in my submission, as I say, until 4th of January 2017. It may also assist your lordships on the question of an auditor. Is contemporaneous correspondence from the company itself, 9th of September 2010, page 83 of the supplementary bundle.
I'm so sorry, which page?
83.
83, thank you.
This is between another lever at the time. So we have Schwab Ibrahim, who is both legal partner and shareholder in the company. And it's to Judith Brown, Dr. Brown, who left at the same time, around the same time. The first paragraph says, as you know, the shareholders, second sentence, as you know, the shareholders' agreement stipulates clearly that if no agreement is reached between the parties, auditors of the company should determine the fair value of the share price. The last sentence says, therefore imperative on that page, it's therefore imperative not take a rigid and hard position on this matter, and do advise it should be common ground. And at page 84, it says, David Hubbard is, we're advised by David Hubbard, he's not the expert in share values, he's not an auditor. Based on the previous share value by Chris Hughes, he put a price at approximately £27 per share. However, the directors have resolved that other factors should have been taken in consideration to come to the conclusion of the fair price of the shares. These are a number of factors which this is the directors taking into account. And point 5, point your lordship made, is that independent auditors may cost in the range of £3,000 to £5,000 or perhaps more to ascertain the fair value of the company, including yourself, has to bear the cost. In these circumstances, the company decided that fair value is £20 per share. So, in my submission, the company was well aware that auditors were required, but had come to their own decision on the value of the shares at that time.
Right, and that's helpful for us to know that, but to what extent does it assist your client on the appeal, given that the valuation put by the company on the share is £20, and ultimately the value was determined by the judge was significantly less than that?
I was going to deal with the offer of 24th of September and come to ground 7, but if your lordship permit me to.
Yes, well, I think you should present the appeal.
Yes.
In the order that you think appropriate.
I'm grateful, but I will certainly answer your lordship's question.
So far you've been dealing with certain aspects of the facts.
Yes.
Is there more on the facts?
Just very briefly.
Yes.
With regards to the trial itself, the issues to be decided at trial were, when it said the valuation, it was also the data valuation. So when the report was received, there were two different values, and the submissions that I made in relation to cost to his lordship was that it was not unreasonable of the respondent, having received the valuation report with 2 dates and 2 valuations, it was not unreasonable to then continue to try to get the higher valuation. And it's a submission which I repeat here in terms of why the discretion on cost was correctly exercised. Take this slightly out of sequence. The other general final point to deal with is a pleading, is the plea between the parties. The point I wish to make is that the defendant, throughout the inception of proceedings, had denied that the claimant was entitled to any monies for his shares.
So he denied that claimant...
Denied the claimant was entitled to any money at all,
Right.
on the face of the pleadings.
Well, can you show us that?
Yes. So page 200 and... Well, the friend has taken you through paragraphs. So the amended particulars start at page 208. At page 210, your lordship has been taken through paragraphs 10, 11, 12 as setting out the difficulties we say that the transfer pricing mechanism has not been followed.
Yes.
And then at page 215, paragraph 15. Sorry, page 215, paragraph 16.
Yes.
Amended 16. The claimant seeks the following relief. And the relief sought under the new number 2 is an order that the shares be valued pursuant to the shareholders' agreement, and the monies being their ascertained value paid to the claimant together with interest accrued. And the page 229. At paragraph 25. The defendant denies paragraph 16 in its entirety. It says accordingly, and when one reviews the responses above, page 220 onwards, the reply paragraphs, there is not a paragraph in there that says it is accepted that the claimant is entitled to the value of the shares.
I'm baffled by that submission. Let's just take, by way of example, paragraph 17.7, where it is pleaded, and I don't understand this plea is factually incorrect, that payments were sent to the claimant as proceeds of the sale of the shares were rejected. Payment of 7,000 odd sent in June 2011 by cheque, never cashed. Further payment 24,000 by cheque sent July 2020, refused to cash. So that is a plain and explicit acceptance. The claimant is entitled to be paid, is it not? And it's a defence of tender.
Your Lordship is correct. Perhaps I should rephrase my submission. That it is a defence of tender, so perhaps I should retract that submission and say that one would have expected something in paragraph 25 to accept that the shares remain to be valued and that payment is still due.
But that wasn't the defendant's position. The defendant's position, as pleaded earlier in the defence, as we can see, is that the shares had been valued and had been valued in accordance with the shareholders' agreement. Now, of course, your client disputed that, and as I understand it, disputes that to this day. But nevertheless, that was the defendant's position, which is that there had been a valuation in accordance with the agreement, and that's why they said they tendered the monies. Is that not correct?
That's correct in respect to the defendant's position, yes, my lord.
And when Mr. Coppell took us to paragraph 25, he emphasised the word further. When he said it is further denied, the claimant is entitled to any further relief. In other words, accepting, there is obviously the entitlement reflected in the tender which had been made. And the point is that the defence is not accepting as any further liability apart from that.
I'll perhaps move on from that submission.
All right.
Thank you.
That's very helpful. Thank you. Mr. Dillon, are those your factual points? Or
Yes.
Very good. Thank you.
My lord, I turn then to round one.
Yes.
Which is that the, as you heard, is essentially is that the judge in his first two judgments had not decided the point that the transfer pricing mechanism had not been followed. So he had not decided that point. And one point that was taken against the respondent is that the claimant chose not to proceed with that point. I do wish to take the court through the transcripts to show that whilst the judge in his ultimate judgment on costs had decided that the mechanism had not been followed, it was a matter that had been fully argued before him. In my learned friend, or certainly by the claimant, my learned friend's skeleton argument mentions it as it's no more than passing. So I propose to take your lordship through the transcripts to show where, certainly from the claimant's perspective, it was argued that the transfer, the provisions of clause 11 have not been complied with.
So just to be clear, what you're telling us is that the judge made a decision that the defendant was in breach of the shareholders' agreement.
Yes.
And
In
that's
exchange
nowhere
with-
to be found in his judgment.
Not in his judgment. No, my lord. It's not in his judgment. But the point that was taken is that the claimant chose not to pursue the point that the transfer pricing mechanism not being followed. Perhaps I should clarify.
Yes.
I will take your lordship through the transcript to show that it was fully argued before his
Yeah.
lordship.
You're making the submission that you did pursue the argument.
Yes.
But in answer to my lord's question, are you saying that the judge decided that in your favour, or are you just saying that he didn't decide it, even though I did argue it?
The respondent's notice, which I prepared, cited additional reasons for supporting the judge's decision, and the additional reasons which I aim to persuade your lordships on is that the pricing mechanism was not followed. Now, it is probably highly likely that this court is not going to rule on whether it was or
Well,
wasn't followed.
I may have misunderstood, but I thought that you'd been refused permission to raise those points. Have I misunderstood?
No, I wasn't seeking the points on which we sought permission to appeal. We've been refused.
Yes.
What I was seeking to do was to try to rely on additional reasons.
Yes, but the difficulty, if you're going to run the additional reason that there was in fact a breach of the shareholders' agreement, the difficulty with that is tantamount to an appeal against the judge's trial judgment, as it seems to me.
Yes.
But persuade me I'm wrong if I'm wrong.
No, the way your lordship has put it is correct. I'll try to refine it further. What I will seek to persuade your lordship is that certainly within the transcript and the exchanges with myself,
Yes.
I will seek to persuade your lordship that the judge has in fact decided that the provisions have not been followed.
I see. All right. Well, But you show us the bits in the transcript that you
Yes.
want to take us to,
Yes.
rather than us having a preliminary argument about what it is that you're going to argue for.
Yes.
Thanks very much.
Yes. So within the core bundle, page 81.
Yes.
This is following where I've been refused permission to amend, and I'm in discussions with the learned judge as to with his lordship as to what is the correct date to value the shares, and at the bottom of page 81G, 81GH, I take his lordship through the provisions of clause 4, and I say that the transfer price is to be determined by auditors, and or is not be determined by auditor of the company at any stage prior to these proceedings. What is said against the claim in the witness statement is that auditors is a mistake, and what is meant is accountants because the company is exempt from audit. In my submission, that cannot be correct. The judge then has a long response to myself, where the judge essentially says that there is no need, essentially why is there a need for an auditor, which continues over the next couple of pages. Top of page 83A, he says the IRA is not so sure that what you need is an auditor at all, what you actually need is a surveyor. I seek to persuade him otherwise. At 83F, he asks why an auditor, what is an auditor going to tell me? An auditor is only going to tell me which money has come to the company as of 2011. I respond by saying that the auditor will verify the accounts. Page 84B, he says the shareholders' agreement certainly differentiates, 84AB, I state that the shareholders' agreement certainly differentiates between an accountant and auditor in other, and his lordship interrupts, says, I accept that, you're telling me you need an auditor. I accept that under these terms it says an auditor. I accept that, I'm not arguing against that at all. I'm not putting that proposition, it is clear, it does. And then there's a further exchange where the learned judge is struggling to see why an auditor is required rather than an accountant. I put it clearly 84, yeah, the first part, defendants have not complied any stage prior to the proceeding with the appointment of an auditor to value the shares. He said, thank you, that is fine. And 84G, so I think that's when it said that is fine. If all we are talking about is that is what is said in the definition provision, I understand that. Well, going forward to 88H.
Sorry, which page?
88.
Thank you very much.
I just summarise for the sake of completeness. Essentially, the defendants have not complied with anything to do with 11. Once a deemed transfer notice, and then the transcript misses it, at some point the deemed transfer notice must expire. So, and at 89H, when I asked just for a moment, he says, I think we've gone through the failure to comply with the terms. Again, I'm not trying to stop you saying anything. I think you're on to valuation date in accordance with your roadmap. Then you're going on to remedies. So certainly from the claimant's perspective, the issue as to compliance with the clause 11.4 as to the pricing mechanism, that was fully argued. And perhaps I, just before lunch, just page 90E, the response of the defendants.
Yes.
Sort of DE, it's starts perhaps a starting point from you to focus on the pleadings of relief sought by the claimant in these proceedings. And then 3 or 4 lines down it says, as far as the court is concerned, I'm not going to deal with the issues of the failure to comply with the provision of clause 11.4 simply because of the observations of the court.
Yes.
So that may be a convenient point to
Yes.
pause.
Yes. Now, Mr. Dillon, I don't want to put any pressure on you at
Yes.
all, but are you able to tell me how long you think you'll be this afternoon?
My Lordship, I suspect I may be approximately an hour and 10 minutes or so.
Right. Thank you very much. Well, that should leave plenty of time for a reply.
Yes.
Very well. We'll adjourn until 2 o'clock.
All rise.
Isn't it? Your timing. He said bang